I think, in a way, the best place to start this discussion is, of course, with the Pentagon Papers case. And I like to think about it through the lens of Alexander Bickel. Bickel was the Yale law professor whom the Times hired to argue the Pentagon Papers case after its usual outside counsel, and I say this with some pleasure because they're now defunct, Lord Day and Lord, abandoned us at our moment of crisis, saying that the publication of the papers was an act of treason. At the Pentagon Papers argument, there was an exchange, a very illuminating exchange, and I think one that will start to frame the issues we'll be talking about, between Justice Potter Stewart, who asked Bickel, what if publication of the papers, they were a secret history of the Vietnam War, quote, would result in the sentencing to death of 1,000 young men whose only offense had been that they were 19 years old and had low draft numbers? That's a hard question, and Bickel did what any sensible Supreme Court advocate would do. He tried to duck the question. You would say, he said, that the Constitution requires that it be published and that these men die, at which point Bickel yielded. I'm afraid, he said, that my inclinations of humanity overcome the somewhat more abstract devotion to the First Amendment. Now, that response was very controversial at the time, so much so that the ACLU filed a supplemental amicus brief after argument, disavowing Bickel's answer and saying the correct response would have been, in its words, painfully but simply, that free people are entitled to evaluate evidence concerning the government's conduct for themselves, come what may. Bickel collected some of his thoughts on government secrecy in a classic 1975 book called The Morality of Consent. Bickel wrote this: not everything is fit to print. There is to be regard for at least probable factual accuracy, for danger to innocent lives, for human decencies, and even, if cautiously, for nonpartisan consideration of the national interest. Now, I'm going to posit that much of this on both sides is gone, or at least in the process of breaking down. The great democratization of information on the internet, notably in the form of Wikileaks, means there is no responsible party to negotiate with on the other side. For better or worse, we held back on the warrantless wiretapping story, in part because we consulted with and were persuaded by things the government was telling us. We may have made the wrong decision, but it wasn't for want of trying to get it right, to trying to strike the balance correctly. That doesn't seem to be the case in many quarters on the internet today. So we live in a new world. We live in a world in which the Bickel paradigm seems to be breaking down on both ends, and we're going to kick those issues around with a really terrific panel.
There was a federal shield law proposed when Sam Ervin was the chairman of the Committee on Constitutional Rights in the Senate, and he had hearings. And I remember testifying at that time before him. And the big issue, of course, then was, well, isn't this, in order to have a shield law, don't you have to say who's a journalist? And if you have to say who's a journalist, then aren't you licensing the press? I've been very surprised that a shield law has gone as far as it has this time, although it is studded with exceptions, as you know. I think my position on it is different now than it was then, because I think the position of the press is more difficult now than it was then. There's been so much hostility in recent years, but particularly in this circuit, to journalist privilege, that I think a shield law is worth bearing some of the problems that it undoubtedly has.
But I do think that there was something very different about the WikiLeaks document dump. Number one, that it was a document dump, which I think is significant. Two, I think it's the scope of, and scope really shouldn't matter in terms of First Amendment law, that it really should be the principle that matters, but I think the scope of the amount of information that was sent out there, and I think also the method, the relatively decentralized, and some people would say uncontrolled method of getting the information out there, I think does really put a dent into the shield debate. But I mean, I would throw out, with respect, that there is a certain proprietary nature that I think news organizations, and especially corporate news organizations, have with respect to what is the proper entity, what are the proper controls that are put into place so that we can all be assured that information that is really geared towards making stuff public as opposed to harming troops is going to be out there. I don't think that that really works. And B, I'm more in favor of having shield laws that extend towards things like WikiLeaks as opposed to having them focused on either brick and mortar reporters or institutions that are taking responsibility for the information. We have to remember that the New York Times didn't put out this particular information, but I think Der Spiegel did, and there were other groups that did as well that aren't in the United States. But I think the nature of the game has changed, and rather than reacting to the scope and the ferocity with which information is dumped, I think people should be looking towards protecting the people that are putting out that very useful information that includes things like the people that were killed in Iraq that we didn't know about, and also, frankly, that talked about the torture that was happening and who knew about the torture, which we didn't know before, or we might not have been able to show before those documents were out there.
Sometimes people are not putting out useful information. They are putting out information simply for a political purpose. And Crew Representative Valerie Plame Wilson, certainly when there were reporters who were aware of which government officials deliberately leaked Valerie's covert identity, that doesn't seem to me like the kind of material that ought to be protected in any way. And I'm not in favor of a reporter's privilege. I can say that I grant that certainly figuring out somebody's motives for leaking may be hard, but this would perhaps go back to my earlier point, which is if you're leaking a source, for example, that doesn't require you to figure into the motives, but leaking a covert operative's identity is clearly a source that I think would be covered under any definition of national security, whatever you might use.
I would be against going into motive. Why do people make a speech? They have a bad motive, a good motive. This invites subjective preferences. This invites the application of the subjective preferences of the people deciding such issues, which is a dangerous way to leave it. I think there should be either a carte blanche privilege, or there shouldn't be. But I think when you get into motives, you get into really no protection, because it's the unpopular motive that probably needs the protection.
And I think you should disentangle two thoughts. One is that the job of journalism is to get to the facts. And to the extent that the transaction results in going in any direction but getting at the facts, it's not something we ought to be interested in. But quite often, people for mixed or bad motives will tell you accurate things. And I don't know that there are less deserving of confidential source protection than people who tell it because they're Boy Scouts and altruists.